Your Majesty, my name is John Wyllie, Dad, Citizen, Founder, Chairman and Interim CEO of Your News Group Limited. Firstly, please kindly note the enjoyment myself and many millions of fellow citizens around the world got from the Prince Philip Memorial Mass on the 29th of March 2022 at Westminster Abbey. Your Majesty, unfortunately, I'm also a former inmate of Lomoss Prison in Bishopbriggs, Scotland, held at Her Majesty's pleasure, or perhaps not, as the case may be, for a period of 10 weeks. Many years ago now, a complete miscarriage of justice, in my view, and one of the reasons Your News was born. It is with deep regret that I find myself in a position having to address Your Majesty directly and publicly. However, I am left with no option, having suffered miscarriage of justice by Crown process, procedure and judiciary. Furthermore, I have given your Crown Royal High Court Justices and your Crown Supreme Court Justices multiple occasions to correct their erred judgments in fact and law. It has by default created a 7 trillion GBP / pound sterling catastrophic problem for the UK and global economy, with the Crown having declared my life and all of my fellow citizens' lives in the United Kingdom and global citizens' lives, future generations and past generations' lives, retrospectively backdating to 1774 as worthless, when George III, King of Great Britain and Ireland, executed royal assent on recommendation from your UK Lords and UK Parliament. Should the erred facts, laws and judgments handed down by your Crown Judiciary not be corrected by the Crown by way of judiciary atonement in the claimants / appellants' favour, either in public or private, and the far-reaching consequences of the UK and global economy will extend to the public-funded UK judiciary, the Union, UK Lords, Privy Councillors, the interests of justice, the Crown, your heirs and successors. Without rehashing over all the details in a public forum, the claimants lodged a judicial review against FSCS in February 2020, court reference CO/629/2020, having erred in fact and law. This matter concerns life, critical illness, income protection and medical insurance, and all far-reaching intra-connected issues concerning insurable interest in an individual, an employee, an employer, a trustee, a beneficiary, a domestic and or commercial mortgage holder with standard securities issued by the UK banking institution. In February 2020, I travelled from Scotland to London by train to lodge my English and Welsh legal claim against FSCS by lodging a suitcase of evidence with the Royal High Court of Justice. Things started off reasonably well from a process and procedure perspective after I eventually navigated my way around the Royal Court of Justice building, having humped a suitcase of evidence up and down multiple stairs unnecessarily and ended up in a judge's chambers by mistake due to inadequate wayfinding signage providing clear direction to the Administrative Court Office. God help my fellow citizens utilising a wheelchair and trying to submit a claim in person. My case was placed into the hands of the Court QC, Joe Teagill, who did his job comprehensively by reviewing all evidence as stipulated in the pre-reading requirements and stipulations, clearly and undeniably narrated within the claimant's skeleton argument and evidence bundles, and respectfully progressed the matter to the next stage of the court process, having identified merit. The case was then placed before Lady Justice Tipples, DBE, who followed suit by conducting her job comprehensively in a fit and proper manner, made issue said directions within her ladyship's order to the parties on the 24th of February 2020, court ref CO/629/2020, and the case progressed to the next stage in the court process, having identified merit. The case was then placed before Mr Justice Garnham. This is where the case started to go horribly wrong, as the matter was dealt with on papers only and without a hearing. His Lordship issued his judgment dated the 6th of April 2020, my birthday, court reference C0629/2020. It is unequivocal for anyone with half a brain cell to see that Mr Justice Garnham did not do his job properly, incorporating his pre-reading requirements and stipulations, and cross-referencing with all of the all-encompassing evidence lodged with the courts in place before him, resulting in the judge misinterpreting the facts and evidence, undeniably and spectacularly erring in fact and law. Furthermore, and more notably, Mr Justice Garnham failed to acknowledge and respond on 3 separate occasions to the claimant's statement of reasons request, seeking clarity on his erred judgment as a matter of fact and law, breaking down each legal element of the matter supported by fact and law, while separating the legal nuances into granular detail. Furthermore, his lordship avoided, confused and distracted away at the merits of the case by erring in his approach and failing to take account of the full comprehension of circumstances, construction and background facts, line by line, evidence bundle by evidence bundle, and aligning the facts and evidence in accordance with public law standards of legality and what any member of the public deserves and expects from all members of the public-funded judiciary. Mr Justice Garnham failed to respond on every single occasion for reasons known only to himself. As a further injustice to the claimants, Mr Justice Garnham ordered the appellant to pay an unlawful $7,200 expenses bill for not having done his job properly when erring, which is a shameful, immoral, unethical and scandalous act for any member of the judiciary to commit, resulting in an undeniable injustice and miscarriage of justice for the claimants once again. A complete slap on the face that can't be allowed to go unchallenged for many reasons, and no wonder the suicide rate and mental health issues in the UK are sky high. The claimants then had to submit a renewal application to the courts. The case was then listed and allocated to Mr Justice Fordham. Good guy, but he's a human being and he undeniably erred. On the 6th of May 2020, case reference CO/4302/2019, as his lordship undeniably erred by erroneously omitting to conduct the pre-reading requirements and stipulation and cross-reference with all evidence lodged before the courts prior to the hearing. Mr Justice Fordham further erred by failing to adjudicate on the nuances pertaining to the matter. Does a human being have an insurable interest? Does an employee have an insurable interest? Does an employer have an insurable interest? Does a beneficiary have an insurable interest? Etc, etc. The judge did not adjudicate on the validity of any insurance policy type or insurer position. His lordship erred by omitting to review the claimants/appellant's lodged evidence. If he reviewed the insurer position, he would have clearly seen each insurer position proven without question that the defendants had erred in fact and law. If Mr Justice Fordham adjudicated on any insurer position, he would have had to bring out his calculator and start the quantification process. He handed down his extempore ruling and proceeded to order that Mr Justice Garnham's order of $7,200 for expenses should remain liable. I then contacted the judge directly, seeking permission to appeal to the Court of Appeal. The claimant's permission to the appeal request was duly granted by his lordship on May 2020, and that was gratefully appreciated. The claimant's appeal to the Court of Appeal was successfully lodged on time within 7 days in May 2020, case reference C1/2020/0758. As part of the claimant's application, I requested the Court of Appeal do 3 things. 1. Provide a fair and substantive hearing. 2. For the judges to be fair. And 3. For the judges to correctly apply the law and uphold the rule of law in accordance with public law standards of legality and in line with open justice principles. None of the above has happened. Notably, at this point, the Crown had lost all the appellate's evidence on multiple occasions, and the Lord Chief Justice having to interpose and direct a senior member of the operational management to take control of the matter. The Crown officers of the court couldn't open the claimant's PDF evidence bundles due to allegedly having unfit and out-of-date technology. So the appellant bundled his hard copy evidence bundles into chronological order, had his work checked with trustworthy witnesses, and sent his evidence via Royal Mail Track service. The documents were lost on multiple occasions by officers of Her Majesty's court service, after being signed off by Her Majesty's officers of the court, and then found. It has subsequently been established that the electronic evidence bundles initially lodged by the claimants/appellants with Her Majesty's Royal Court of Justice had been successfully opened and viewed and read multiple times, as my pixel evidence successfully demonstrates. The claimant/appellant was ultimately led a merry dance by Her Majesty's Royal High Court Justice, proving beyond reasonable doubt of the outright negligent and dishonest actions being advanced by the Crown, which can all be easily evidenced by return. An outright symbolic showcase of how the Royal Court of Justice is securing and handling evidence, resulting in mass-scale miscarriage of justice in the name of the Crown. The matter was allocated to Lady Justice Carr, case reference C1/2020/0758. Apparently senior members of the judiciary were refusing to take the case being placed into the hands of Lady Justice Carr, for reasons that will become apparent in due course if the erred judgments are not corrected by the Crown via judicial atonement. At this juncture, I will not chastise Her Ladyship's judgment or lack thereof. However, Her Ladyship's order must be corrected as a matter of fact and law, as Her Ladyship has invalidated every life, critical illness, income protection, key man/person and medical insurance policy in the United Kingdom, having accepted and declared FSCS position as a matter of fact, resulting in many multi-trillion issues that the Crown now must address concerning millions of lives and retrospectively backdating to 1774. This is what happens when facts and legal nuances are whitewashed and the judiciary are not doing their public funded jobs properly. Your Majesty, pause, clear your mind and think about this. 1. If an individual, me, Prince Philip, Boris Johnson, Mary down the street, does not have an insurable interest in their own life, then why is the insurance market in the United Kingdom, the fourth largest market in the world, selling life insurance policies retrospectively backdating from 1774? 2. Why are insurers collecting circa 30 million premiums per month for incepted and on-risk life insurance policies and 5 million key man person insurance policies that will never pay out in the event of a claim to the policy owners or beneficiaries concerning my fellow UK and global citizens' lives who allegedly do not have an insurable interest in their own life? 3. By Lady Justice Carr accepting and declaring that an individual does not have an insurable interest in their own life means that Her Ladyship has in effect declared all of my fellow citizens' life is worthless, zero value, and not worth the paper in which a life insurance policy is written on, from a multifold perspective when you evaluate the nuances in granular detail. Clearly, I cannot accept the Crown's position as a matter of fact and law that my life, my mother's life, my grandmother's life, my son's life, my friends' lives, my neighbours' lives, my beneficiaries' lives, employees' lives, secured employees' lives, fellow citizens' lives as worthless. Also, I cannot accept that my ancestors' lives as worthless either, backdating to 1774, when George III executed royal assent. This third judgment issued by Lady Justice Carr affects the full cross-section of society. Not one citizen goes unharmed by Lady Justice Carr's order, and it has a catastrophic effect to the world if the erred order is not corrected by the Crown. Furthermore, as a matter of fact, Lady Justice Carr erred by not applying the nuances in law in relation to each element of the claim, in accordance with public law standards of legality, resulting in Her Ladyship invalidating every life, critical illness, income protection, key man, key person and medical insurance policy backdating to 1774. Due to the lack of insurable interest. Lady Justice Carr also did not review the insurer's positions, contrary to Her Ladyship's evaluation and inferences. She also did not evaluate the doctrine of precedents concerning case law, or apply the law and statute, or the FSCS rules as clearly narrated within the rulebook. At this point, I wish to confirm that no misrepresentation has been committed by the claimants or appellants in any way whatsoever. Only the respondents and the Crown officials have erred by misinterpreting and misdirecting themselves in fact and law. I submit to you that my fellow citizens' human lives are not worthless, as confirmed by your Crown appointments to the Royal High Court of Justice, and state for the record as a matter of fact and law that a life has an unlimited amount of insurable interest as narrated and defined at 10.2.3 of the FCA Handbook at Section 4, subsection A, B and 5. 1. An individual does indeed have an insurable interest in their own life. 2. An employer does indeed have an insurable interest in the life of an employee, etal. A beneficiary/trustee does indeed have an interest in an assignation made in their favour. Now pause and think about this. Jimmy down the street goes for a mortgage to the bank, any banking institution in the UK. Yep, Jimmy, we'll give you your 200 grand for your house, no problem at all. But we want you to take out a life insurance policy in the event of your demise. Okay, no problem. How much is that going to cost? £30, £60, whatever the premium's going to be. But Lady Justice Carr has just ruled that his life is worthless. And if you take it a step further, the standard securities that the banks are now issuing to everybody in the United Kingdom as a result of Lady Justice Carr's order has now been invalidated. So she has effectively invalidated all of the standard securities for the entire banking institution of the United Kingdom. No breach of the Life Assurance Act 1774 has taken place at all, nor as a direct result of my company's actions. No breach of the Insurance Act 2015 has taken place at all, nor as a result of my company's actions. The fact still remains, all policies were advised upon and arranged by the broker, an FCA regulated and accredited broker as defined within my evidence. Substantial material evidence originally lodged with the courts by myself, both in person and electronically back in 2020, has failed to be taken into account, proving that the evidence has unequivocally been ignored by your Royal High Court judges, resulting in the claimants/appellants still being owed more than £170,000 in premium. Now, if you refer to Lady Justice Carr's order, she states that no loss of premiums, that I shouldn't have suffered any loss of premiums. She didn't review the evidence as narrated in the bank statements or the spreadsheets that was lodged before the court, proving that that was the amount that was still owed in relation to loss of premiums. Your Majesty, clearly and undeniably, Lady Justice Carr has erred in fact and law, probably the worst adjudication to ever go down in history, resulting in human life in the UK being declared as invalid, akin to worthless by the Crown, invalidating every life, critical illness, income protection, key man, key person and medical insurance policy backdating to 1774, albeit I have several insurers with multi-trillions in assets backing my position in fact and law, which is contrary to Lady Justice Carr's evaluation and ruling, and by default affecting every country in the United Kingdom, Scotland, England, Ireland and Wales. I then attempted to appeal the order of Lady Justice Carr to the UK Supreme Court. However, Civil Appeals Master Bancroft Rimmer stated on the record, the Court of Appeal is bound by the powers that are given to it by Parliament, that's your UK Lords, and accordingly, the Court cannot grant permission to appeal to the Supreme Court where UK Parliament has specifically denied such an appeal. Unfortunately, the Civil Appeals Office is able to assist further. Your Majesty, pause, clear your mind and think about this position in a rational manner and the potential ramifications to follow if the current position held by the Crown and the Court of Appeal by refusing to correct the erred order, or worse, ignores civil procedure rules as narrated at 52 brackets 6 brackets 1 brackets B. I invite your Majesty to conclude that public significance pertains to this matter, backdating to 1774, and more than merits my case to be heard on this compelling ground alone, and for the case to be granted a fair and substantive hearing in the interests of my fellow UK and global citizens, justice, the Crown, your heirs and successors, and the UK and global economy. Furthermore, the position is also at odds with Lord Kerr, UK Supreme Court Justice, and his position on the Constitutional Reform Act 2005. Court system was established as a separate entity. As Lord Kerr has outlined, the fundamental principles concerning the separation of powers are between those who make the laws, parliaments, and those who adjudicate on difficult points of law, Supreme Court. Some of the unique and complex legal issues and nuances set out with the Court of Appeal's jurisdiction. For example, there is no statutory definition of insurance, as defined and narrated within HMRC Internal Manual at reference GIM 1020. There is also no statutory definition for key man person insurance. Therefore, UK Supreme Court justices have an opportunity to make the position crystal clear on insurance, insurable interest, key man, key person insurance is clear as day, without any confusion, and live stream for the entire world to know the rules of the game. I have outlined my position within my skeleton argument. It should be noted at this point, Lady Justice Carr threatened the claimants/appellants, myself and my companies with a civil restraint order within her order if the claimants challenged her undeniable earned order, declaring on behalf of the Crown that myself and all my fellow citizens' lives are invalid, akin to worthless, by having zero insurable interest. I take the view that Lady Justice Carr is undeniably wrong on so many levels and out of step, and it would appear that her ladyship is abusing her power and authority with her inaction, knowing fine well her ladyship has erred. I would invite your Majesty to seriously consider if her ladyship's position is tenable in accordance with the powers given to you in Section 11, brackets 3 of the Supreme Court Act 1981, as amended from the 1701 Act of Settlement. Pause and consider this scenario. If a judge incarcerates, jails someone due to an error they have made, that error has been pointed out, but they just sit back and do nothing. Do you see that as a rational course of action and approach to take? I don't. Do you see this as a rational approach? Of course you wouldn't. No rational person would find the approach rational. Your judiciary has not viewed and evaluated my evidence properly and misinterpreted the facts and law, and therefore undeniably erred in law in any event, and allegedly had no external interference in relation to the case. The case was then placed before Lord Legate, the United Kingdom Supreme Court Justice, and decided on papers, again without a hearing. The significant grounds advanced before the UK Supreme Court Judiciary by the claimants/appellants incorporated 1. The Constitutional Reform Act 2005, 2. Civil Procedure Rule 52 brackets 6 brackets 1 brackets B, compelling reasons why the Crown should hear the appellant's case. 3. Process and procedural negligence committed by the Crown. 4. The fact the Crown has invalidated all life, critical illness, income protection and medical insurance policies, resulting in my fellow citizens' lives being declared akin to worthless by the Crown and having wrongly erred in fact and law. How can I possibly not have an insurable interest in my own life? How can I possibly not have an insurable interest in the life of an employee? How can I possibly not have an insurable interest in my medical insurance policy? It's my health, it's my body. How on earth can I possibly not have an insurable interest in my health and well-being? I then received a letter from Robert Greenberg dated the 21st of January 2022 stating, Lord Legate has reviewed the papers and directed as followed. Where the court has refused an application for permission to appeal it from a lower court, Section 54 of the Access to Justice Act 1999 precludes the appeal against the refusal of permission. Access to Justice Act 1999. Perversely, you are not allowing access to justice to happen. In this case, it is therefore not legally possible for Mr. Wyllie to appeal to the Supreme Court against the decision of Lady Justice Carr, which refuses him permission to appeal to the Court of Appeal. Accordingly, the Registrar's decision is correct and Mr. Wyllie's application is dismissed. Her Majesty, you will note Lord Legate has ignored and or admitted to review all grounds and evidence advanced before the UK Supreme Court Judiciary for review. Utterly scandalous on every level imaginable. Your Majesty, my life has value and a net worth of unlimited amounts of insurable interest, as does my fellow citizens' lives, as defined within FCA Handbook at 10.2.3, Section 4, subsection A, B and 5. For the Crown and your Crown-appointed judiciary to declare an individual does not have an insurable interest in his or her own life, an employer does not have an insurable interest in the life of an employee, a beneficiary or a trustee does not have an insurable interest in the assignation made in their favour, as previously discussed, would mean the mortgage market within the UK would not be worth the paper on which the standard securities were written on and duly issued by every banking institution in the United Kingdom. when no breach of the Life Assurance Act 1774 has taken place at all, nor as a direct result of my or my company's actions, and no breach of the Insurance Act 2015 has taken place at all, nor as a result of my or my company's actions. The unlawful position held by the error judgments issued by Her Majesty's Royal High Court of Justice and Crown are self-inflicted coup de grace, and demonstrates how wrong your judiciary and the Crown can get it wrong in fact, law, process and procedures on many occasions, albeit most of them get swept under the carpet and go unchallenged. Maybe it's now time the Crown to abolish the permission to appeal rule for many reasons, alongside other draconian and out-of-step rules, as narrated within Crown civil procedure rules. Since the country is building back better after the global pandemic, I have a list of reality checkpoints ready and available for consideration and scrutinisation should the Civil Procedure Rule Committee wish me to forward that on to them. In the words of Your Majesty, your good self, in your pre-recorded video to world leaders at COP26, it has sometimes been observed that what leaders do for their people today is government and politics, but what they do for the people of tomorrow, that is statesmanship. I concur. I therefore conclude, without hesitation, that my actions are logical, considered, balanced and proportionate, a clear indication of my intent and journey towards statesmanship. Your Majesty, my cri de coeur is as follows. In line with open justice principles, I respectfully invite Her Majesty to expeditiously move the court by directing and granting the Crown's UK Supreme Court Judiciary to provide a full and substantive hearing to hear my submissions on significant, pertinent, unique and complex points of law pertaining to the contemporaneous evidence lodged before the courts by the claimants/appellants and the UK Supreme Court justices to live stream into 195 countries and 44 dependency countries to watch and hear every utterance, perhaps on www.your.news multimedia news platform, overruling section 54.4 of the Access to Justice Act 1999, as this legislation is at odds and conflicts with the Constitutional Reform Act 2005 and perversely prohibits access to justice and does not do as one would suggest and expect as narrated on the tin. Furthermore, the unique and complex legal nuances, the significant public interest pertaining to the case, commands the authoritative powers to be applied in this scenario due to the Court of Appeal judge and 2 High Court judges before Her Ladyship undeniably erring in law, and the UK Supreme Court's dismissive stance, albeit hopefully temporary. 2. For the UK Supreme Court Judiciary to remain unbiased, unprejudiced, fair and impartial. And 3. For the UK Supreme Court Judiciary to correctly apply the law in accordance with public law standards of legality by upholding the rule of law, incorporating statute, doctrine of precedent, case law that I have submitted before the courts, and equity law as defined within English and Welsh law, developed over long-established legal frameworks within the Crown operating system. Should the UK Judiciary now concede that the Court of Appeal judgment is improper, inadmissible, flawed and quite simply invalid, and subsequently grant a substantive hearing before the UK Supreme Court judges with leapfrog status on the basis of the unique and complex legal nuances and variations involved and the improper assessment made by the Administrative Court and the Court of Appeal, I will, without hesitation, proceed on my mission to deploy Citizen Supreme Court Limited. This will pave the way to ensure undeniable injustice is corrected and will offer protection to all fellow UK citizens and their respective future generations from having to suffer judicial, Crown injustice and failure in the future. Your Majesty, your heirs and successors, I start where I stand and will not back down to any member of the judiciary, irrespective of rank or position in society, as they have undeniably erred and made an utter mockery out of the Crown court system by default. Your Majesty, please note, I am happy to single-handedly go head-to-head against any number of lawyers, law firms, barristers and leading chambers who wish to challenge me on points of law pertaining to this subject matter. What has the courts and the judiciary got to be afraid of by granting a full and substantive hearing before the UK Supreme Court justices? That will correct a wrongdoing committed by the Crown. I'm just a simple guy with limited resource and limited education, a dyslexic, disabled at heart, who has been labelled and treated like an idiot and called dumb, thick, daft and stupid and won't amount to anything throughout his life, versus all the lawyers and all the barristers with their fancy accolades and education from Oxford and Cambridge. There are two types of people in life: those who one imagines to be trustworthy and reliable, who turn out to be treacherous and weak, not me, and those who appear to be complex and difficult, who turn out to be more dependable than anyone could ever imagine, me. I'm grateful to Your Majesty for her indulgence, and I conclude by stating you may have heard of a movement called Black Lives Matter. Well, according to your Crown appointments concerning your Royal High Court judges and justices pertaining to this scenario, no lives matter. Please kindly allow common sense to prevail and Crown atonement be applied by your UK Supreme Court judiciary in this matter. I do not wish Your Majesty's reign to be tarnished in history books by UK and global citizens due to your Crown judiciary erring in fact and law, and by declaring my life and all fellow citizens' lives as worthless and not worth the paper it is written on by UK insurers who are protected by FSCS. Thank you in advance and good day to you. Humbly reported and best wishes, John Wyllie.